So welcome everyone to another session in our career series. Once again, we have Wilson Sonsini here to join us. They've donated some more time to help us understand what the practice of law looks like, and then how to compare one practice to the other, because you've heard you say this before. Firms have different personalities, practices have different organizations, and all of those affect, well, they just simply affect how you'll go through your practice day to day, month to month, and year to year. So it's important to understand what a client base looks like, what a practice organization looks like. And Wilson brings us this interesting perspective of, everybody knows is a high-tech life sciences focused environment, but the litigation is even broader than that. And so how does a litigation practice sit in something that has kind of this brand around technology? So I want to introduce two attorneys, again, who have been willing to donate some time for student education. We have Louise Lee and Trevor Templeton, both from the California offices, I believe the LA offices of Wilson. So again, thank you both for joining, and thank you for giving some time to us.
Thanks, Wayne.
Thank you.
So I want to start with, there are a lot of words out there that come before litigation when you start reading about firm practices. There's patent litigation, there's trade secret litigation, there's SEC litigation. Firms advertise all of these specialties. You might see general litigation. That's a big common word to separate from IP litigation. And Wilson uses another term, complex litigation. So adding to that mix of confusion for students that just thought that there was corporate law and litigation law. So what does complex litigation mean in your world, and how does that compare to what other people might do?
Well, Wayne, it's complex. Let me
couldn't resist that, could you?
I couldn't. Let me try to explain. So at Wilson, there are a number of practice areas: patent, various type, trademark. We have a internet strategies group that deals with sort of all the way from that's very internet focused. And we have an SEC practice, we have investigations, we have all of the sort of practice areas that many of the big law firms do. Complex lit is intended to provide the litigation chops, the trial chops, the discovery chops, the motion writing chops, even the appellate chops, to all of those different areas, and to sort of, so for instance, in my practice area, I'm working on a patent case. I've got a trademark case. I did a civil rights case earlier. We did an executive termination arbitration recently. And so it's a very broad range, interdisciplinary range of practices. And so when we're talking about the complex lit group at Wilson, that's what we're talking about, which is a sort of a broad-based area of litigation, where if a particular practice area, wants more, sort of traditional, just basic litigation chops to add to their team, we would raise our hands and ask to be signed up.
And if I'll just add one quick thing there, it's as sort of implied in Luis's response, we're sort of generalists in our approach. We we have a particular skill set and knowledge base that we bring to bear on the cases that we work on, and that's basically just the skills of litigation. It's brief writing, it's advocacy, it's case development and investigation. Those are skill sets that can be applied to a range of matters in different industries, different subject matters, different types of law, but it is very much a skill set that you develop by being a litigator. And the knowledge base is, the knowledge to do things like depositions and investigate cases, but also, knowledge of the procedural rules that govern how cases are litigated. These are things that we bring to bear and can use to backstop other teams in particular subject matters that really helps, deliver a better result for the client.
Well, I know some firms use the term general litigation and they end up dividing their litigation group into general litigation and IP litigation. And then those are their two branches under the litigation category. It sounds to me that you don't have that division. When you say complex litigation, it's both of those things.
Yeah, I think that's accurate. I think
Okay.
what we've been, some of this, we both, Trevor and I, joined Wilson from Munger, Tolles and Olson probably a couple years ago, and the idea was to sort of incorporate a sort of typical traditional high stakes litigation shop, and so we came over with probably five other folks to incorporate a traditional high stakes litigation shop into the Wilson model, which had these various practice areas. And so just by way of example, I mean, so the ship has nothing to do with anything other than I bought it on eBay for $300 and I thought it was cool. But that little white plastic thing here, that is a blowout preventer that was used to cap the well on the Deepwater Horizon. So I have I helped try that case a few years ago. These little pots here are not real Greek antiquities, but I've been working on sort of museum antiquities cases for the last 15, 20 years. And so that's kind of the range of types of practices that I've been involved in. I've got matters in front of the European Court of Human Rights that relate to antiquities. And, I've worked on, oil blowouts and, oil rigs that had issues in Oklahoma or whatever, like a wide range of practice. And so what we've tried to do is take those types of experience. Trevor and I worked on wildfire cases together, as did some of the other partners, who have joined. And the idea is to take that broad range of experiences and make them available to all of the various teams at Wilson, to if a matter is going to trial or if a matter has, substantial litigation ahead of it, we can jump in and help.
So Trevor, let me ask you. I mean, I see some firms say, well, you need to be a specialist to keep up in today's world. You've got to be a very narrow litigator, same type of clients, for your entire career. And what you're talking about is a much broader type of client, much broader set of laws. We're moving across multiple different laws, where I spent my life with 3 statutes. I can still see them burned on the back of my eyelids when I close my eyes. How do you manage that kind of breadth? I mean, it seems exciting, and to like you'd never be bored. It also seems a little overwhelming to go between all those different areas.
Yeah, no, it is exciting. And in fact, it's the most exciting, the thing that I like most about my job is the fact that it's, every case that we work on is different and often involves working with very different clients in very different industries with very different kinds of problems. To me, jumping into a dispute and sort of learning a client's business and learning their worldview and perspective and the issues that they're confronting, to me, that process of sort of getting up to speed, learning what I need to know about the industry and the client in order to successfully and effectively advocate for them is the best part of the job. And so that's why I love being a generalist. In terms of what, how to manage the complexity or difficulty of that, I guess I'd bring it back to the first thing that I said, which is that really being a litigator in our practice group involves a set of skills that can be applied in any matter that we take on. It's knowing how to advocate, knowing how to be a storyteller on behalf of the client, learning how to ask the right kinds of questions to be able to get up to speed and understand what the dispute is, what the issues are, and then learning, understanding how to apply the procedural rules of a case to help manage it from the inception through trial. Those are all skills that you learn by being a litigator and can be applied across a range of matters.
Well, as I look at this, the one thing I want to make sure everybody has a perspective of is, what complex litigation really means in a law firm of this size and this sophistication. I guess a typical case is not defined by months, it's often by years. So you do have a lot of time to get familiar with the relevant regulations, relevant laws, where maybe if it's non-complex litigation, the simpler litigations that typically don't find their way into big law, the turnover is in months often. So I guess with that in mind, the question would be, how long do you typically spend on a case? And I know some settle out very quickly, but once you engage, are you there for 12 months, 18 months, 36 months? I was on a case that lasted 21 years. Really, it's
Yeah.
terrible.
Well, I guess I would say, it's the whole spectrum, right? So Trevor and I just did an arbitration with another one of our partners that I, probably lasted about a little over a year, but not much. And so we got the case, early in, and did the discovery, did all the document stuff, took and defended a bunch of depositions, and just tried it in the hearing 2 weeks ago. We're in the midst of writing the post trial briefs now, so that's probably the shorter time frames. I've got a matter for a museum that, as I said to you earlier, is in front of the European Court of Human Rights that I've had since probably about 2007. And so it's so that it can go, these things can go a very long time. The normal case is, maybe 2 years, 2 or 3 years. Trevor and I have tried, I think since we've started this, since we came to Wilson, we tried a case involving a horse racing at the Santa Anita racetrack up in Santa Anita, involving a trainer. That one probably lasted about, we represented the horse track, and that probably lasted about, what, 2.5 years, give or
Yeah,
take?
2.5 years. Yep.
Yeah. And then right after that, we tried the case involving, we represented Vanessa Bryant, Kobe Bryant's widow, in a case involving where the county employees had taken photographs of the remains, and that was a civil rights case we brought. Those events took place on January 26, 2020, and we tried it in the summer of 2022. And I think we heard about the events in spring of 2020. So that's what, 2 years, give or take. So something like that.
Yeah, and just if I could launch off of that to circle back to something you asked about a second ago, Wayne, about how you're able to sort of jump between different types of matters effectively. I think it really helps to be the type of person who really likes to learn, who really likes to take on new experiences and just learn stuff about the world and the way that it works. In the horse racing case, for example, I mean, horse racing is a very particular kind of thing with a very distinct culture and language that's just different than a typical lawyer in a big law legal practice interacts with. And so just using that as an example, I remember when we started working on that case, getting a bunch of books about horse racing and like famous horses and just reading a bunch about the industry and about horse racing to just understand the language that these people talk about and sort of the cultural context that they have when they're discussing things. People at the client who are talking about their lives and their work. To me, that again, that's something I really love about the job, is learning something that I would otherwise never really have occasion to interact with, an industry or a culture that I never really would interact with. I love that part about the job, just diving in and learning and being able to communicate with the client about their world and their life.
So horse racing, the Vanessa Bryant case, seem a long ways from the stereotypical Wilson high tech or life sciences client. how or do you integrate with Wilson's kind of stereotypical client base?
Yeah, it's awesome. I mean, let me say that, so the company that we just did the arbitration for is a it's confidential, but it's a very, very well known tech company, and it was a very, very high consequence to the company, and it's a client that that was a pre-existing Wilson client, and they were like, this is perfect for you guys, and so jump in and do it. And so that's exactly what we did. There are other matters. I've got a matter right now for a very well-known social media company that's in got a lot of issues right now, and we just have, because we've been doing a lot of different areas with a lot of different counterparties and opponents, and like what I would call like sort of multi-directional cases where you're just getting attacked from a lot of different angles. Take the Deepwater Horizon matter. There isn't an entity anywhere in the southeast part of America that didn't want to be involved in this litigation. Because we've built this level of experience in dealing with sort of all of these clusters of problems. We have skill sets that we can bring to these clients that have, are now, I think 15, 20 years ago, tech companies weren't facing the same kinds of challenges that they're facing now. I think as tech has grown at this sort of, hockey stick way, and as its impact on society has like increased at that same rate, the kinds of problems that they're facing now are just very, very different than the problems that they were facing, even a decade ago. The example I use that I think really, tells, at least tells me something, is that Twitter, right? Twitter 5 years ago, was an important part of the landscape, but not a $44 billion, problem, right? And it's just the growth of these industries have become so, exponential, that, and their impacts and their sort of profile, for regulators, for, everybody, has increased at such a tremendous pace that their litigation needs have also increased at that pace. So I think that's how, like, I think the change has taken place, and that I think Wilson recognizes that sort of having that more traditional sort of here we're going to handle licensing issues for you is not something that works anymore, because the level of risk that the companies are facing is so much higher. So there's a market, is what I'm saying, for this type of practice.
Well, if you're talking to law students when they look at this, look, if you're going to do patent litigation, there's a pretty clear set of courses you could follow to turn out patent litigation. That skill set. I'd try patent litigation 1 and patent litigation 2. I mean, it's pretty straightforward. But there is no complex litigation 1, complex litigation 2. Definitely no law of horse racing class. I think I'm going to propose that just to see how the dean responds. So what does a law student do to prepare for this kind of breadth of practice, and see if that's what they're interested in?
Trevor, you want to?
Yeah,
I went to law school back when Abraham Lincoln was going to law school, so I'm not sure it's as relevant. Go ahead, Trev.
Yeah, probably not. Yeah, so I think well, I can share my own personal experience, which is I really made an effort when I was a law student to try to get a lot of actual practice experience. So I did a lot of clinical work, working with actual clients as a law student, and I found that to be the particular clinics I was in involved stand-up opportunities in front of courts and administrators of different kinds. And so that was a great learning and training experience for me, is actually getting up and advocating on behalf of a client. But that's not the only path. I think the core curriculum in law school, to be successful in just the core curriculum, you need to be very effective at reading and writing and arguing positions. And that's essentially, those are basically the skills that we bring to bear every day on behalf of our clients. So I think, to me, the advice I would give to a law student who's interested in complex litigation would be, it would be to just apply yourself rigorously to the curriculum. And if you enjoy the work of reading cases and arguing positions, there's a good chance that you'll probably enjoy this practice area. I would also seek out courses that involve learning some of the procedural rules that govern complex litigation. So class action litigation, a lot of universities will have courses on class action litigation. That's a very valuable thing to learn. But a lot of the subject matter stuff you pick up from legal practice. It's really the skill is being able to sort of dive into a problem and learn and apply and write and argue effectively.
I would add one course to that.
Point.
I would just add one course to that, which would be evidence. I think evidence is, to me, is the backbone of every trial, whether it's a securities trial or a civil rights trial or a class action lawsuit.
So after my own heart there, I tell students that you don't understand it now, but evidence and civil procedure are actually the tools for winning or losing a case.
Truly.
And a significant number of malpractice suits are based on failure to know those two classes.
True.
You can learn horse racing.
Yeah.
They might forgive you for not knowing an obscure rule of horse racing, but nobody will forgive you for missing a filing deadline on an appeal.
True.
So, definitely, those kind of basic courses are more than basic; they're foundational. So,
I agree.
Well, wonderful. I really appreciate you taking some time to lay the structure out and help students with this. It sounds like Wilson's developed a different type of litigation practice than is typical in Silicon Valley, typical in the tech companies, with kind of a different set of opportunities for growth and a different set of opportunities for learning. But I think the most important thing I picked out of all of this is from you, Trevor. It's great as long as you're curious and you're willing to pick up that book on horse racing and read it. There's no sitting back and just absorbing the same material day after day, year after year. So, which puts more pressure on attorneys and also makes it more exciting. Those often come together.
Yep.
Well, wonderful. Thank you both. And I look forward to talking with you again. Hopefully more about horse racing. I'm really intrigued now.
Thanks a lot, Wayne.
Thank you.
Take care.